Hi, I'm David Henson, Managing Partner of HensonFuerst Attorneys. There are two main types of workers in America, employees and independent contractors. The difference is important and has implications ranging from the benefits the worker receives to the taxes owed by the worker and the employer. So, what's the difference? An employee is someone who works for an employer when assigned, under the employer's terms, at the employer's place of business, furthering the employer's business and profits. An employee receives protections under many federal and state laws, including laws prohibiting discrimination, providing for workers' compensation, and requiring the payment of minimum wage and overtime rates. For each employee, the employer must withhold taxes from payroll and must also pay certain taxes to the government. Independent contractors, on the other hand, are in business for themselves. They enter into a contract with the employer, usually for a specific period of time or for a particular task or tasks. They usually provide their own tools and/or technology in order to complete the job, and they have a greater amount of control over the manner in which they complete the work. Independent contractors are often free to contract with more than one employer, and in this way, they control the profits they make. Independent contractors are also responsible for their own taxes, insurance, and other costs of doing business. It sounds pretty good until you realize that independent contractors do not receive many of the protections under the law as employees. Independent contractors are owed only the pay rate that they contracted to receive, even if this sum amounts to less than minimum wage, and no premium rate is owed even if the contractor works significant overtimes to complete contracted tasks. In other words, independent contractors are not protected by federal and state minimum wage and overtime laws. How can you tell if you're classified as an employee or as an independent contractor? First, look at any pay stubs or tax documents you receive from your employer. Does your pay stub show how much was deducted for state and federal taxes? If money was deducted, then your employer seems to be treating you as an employee. If no money was deducted, if your check is for the full hourly or contracted rate, then your employer may have you classified as an independent contractor. Second, look to see whether you received a W-2 or a 1099 form from your employer at the beginning of the year. If you received a 1099, then you're classified as an independent contractor. Whereas if you got a W-2, then your employer has classified you as an employee, and you have far more protections under the law. The problem is that many employers classify and treat workers as independent contractors when they are properly and actually employees under the law. This misclassification leaves workers unprotected and often underpaid. Just because your employer classifies you as an independent contractor does not mean that you are one. If you're misclassified, you may be owed back wages for unpaid overtime and possibly for minimum wage violations. If you have additional questions about overtime law or other aspects of employment law, please check out some of our other Wage and Hour YouTube videos or the Wage and Hour section of our website at lawmed.com/wageandhour. And if you'd like to explore your legal options, call our Wage and Hour team at 1-800-4LAW-MED. This is David Henson with HensonFuerst Law Office. If you have questions, we have answers.